Sexual harassment at workplace. Hello and welcome back to our channel. Now we are discussing a crucial subject, sexual harassment at workplace and its legal definition, rights and key provisions under the POSH Act. Sexual harassment of women at workplace, prevention, Prohibition and Redressal Act 2013. Sexual harassment is not just about physical assault. It encompasses a wide range of unwanted behaviors, verbal, non-verbal, and psychological, that violate women's rights, right to equality, right to dignity, and safe working environment. We'll see the meaning and scope of sexual harassment. Sexual harassment at the workplace includes any unwelcome acts or behavior of sexual nature, including physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. These acts become harassment when they interfere with work, create hostile environments, or affect a person's safety and well-being. As per Section 2(n) of POSH Acts, this definition is inclusive, not exhaustive. The constitutional and human rights backing, if we see the Article 14, Article 15, Article 19 and 21 of Constitution, sexual harassment violates Article 14, right to equality. Article 15, prohibition of discrimination. Article 19(1)(g), right to practice any profession or occupation. Article 21, right to life and dignity. India is also signatory to international conventions like CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, affirming its commitment to prevent gender-based violence. India is signatory to CEDAW. Who is an aggrieved woman? So, under POSH Act, an aggrieved woman is any woman of any age working in regular, temporary, ad hoc, or daily wages, or contract, probation, trainee, or volunteer capacity, almost all covered, working with or without remuneration, employed directly or through an agent, including domestic workers and even students, or simply visiting a workplace. Almost all women are covered. So what constitutes workplace? We are using the word workplace. So what is workplace? If you see the definition under POSH, is a very broad. This also includes. It includes government and private organizations, educational institutions, hospitals and nursing homes, sports facilities, transportation provided by employer, a dwelling place or house, any place visited during employment, all covered under definition of workplace. Even the unorganized sector and less than 10 employees units also covered. Now, we'll see the forms of sexual harassment. One way is quid pro quo. It is like a promotion in exchange for sexual favors. hostile work environment, creating an intimidating or offensive atmosphere. We'll see the examples: repeated unwelcome sexual advances, sexually colored jokes, emails or memes, physical touching, brushing against someone intentionally, rumor and character assassination. We'll see the detailed provisions under Section 3, subsection 2 of POSH Act. Circumstances amounting to sexual harassment, including implied or explicit promises of preferential treatment, threats of detrimental treatment, interference with the work, creating a hostile or humiliating environment, threat to employment status or health. So these are all the circumstances. These are all the circumstances under Section 3 of POSH Act amounting to sexual harassment. So what is the duty of the employer, responsibility of the employer? Constitute IC, internal committee, in a very office with more than 10 employees. Provide a safe work environment. Display the penal consequences of sexual harassment. Organize awareness programs. This is important. Awareness is important. Is there any time limit for compliance? Within 3 months from the date of incident. Of course, it is extendable by the IC committee. What is the redressal mechanism? Internal committee or local committee investigates. Both the parties get opportunity to be heard. An inquiry report will be submitted within 10 days. Employer to act within 60 days of the report. Report will 10 days, within 10 days, and within 60 days of the report, employer will take action. We'll see few case laws and legal interpretations. In the matter of Apparel Export Promotion Council versus A.K. Chopra, the Supreme Court held that physical contact is not necessary. Any conduct of offensive to modesty is harassment. In another case, S. Razu IL versus JNU, persistent calling, stalking, and vulgar emails are also harassment. In the matter of Mohan Kumar Singh versus Central Bank of India, obscene pictures, pestering via calls, and final assault warranted dismissal despite acquittal in criminal court. In another case, Global Health Private Limited versus District Panchayat, hostile work environment leading to dismissal without appraisal was held to be stigmatic, and there was a compensation of 25 lakhs awarded. Behavior that may not be harassment. So what are those? What is the behavior which will not considered as harassment? Not every workplace conflict is harassment. We'll give an example. Giving a feedback on job performance is not harassment. Normal exercise of supervisory duties is not an harassment. Work-related stress or deadlines is not harassment. Constructive criticism of work is not harassment. So finally, the sexual harassment in the workplace is a serious issue. The POSH Act and backed by constitutional and international rights provides framework for protection. Laws alone are not enough. It requires awareness, responsible behavior with a commitment to dignity at the workplace. We have two channels, RR Corporates, other channel RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of the latest videos. Thank you.